The petition does not contest the constitutionality of processes leading to procurement or the award of tenders relating to JKIA and KETRACO, but they raise constitutionality questions with respect to the PPP Act. Turning, my lady, to the core of the petition, there are two issues that are critical when it comes to PPPs which bear constitutional significance and which we are then seeking or pointing out that have not been complied with. The first issue is that PPP is effectively an aspect of public expenditure. Being an aspect of public expenditure, the Constitution very clearly regulates how public expenditure ought to be undertaken. And specifically, my lady, Articles 95, Article 96, as read with Articles 206, and Article 220 to 223, lay out a framework that ought to be complied with when it comes to the approval, the pre-approval, and the raising and the spending of public funds. And number two, my lady, another aspect of PPPs is that PPPs involve an aspect of procurement. And by the fact that it involves procurement, the Constitution under Article 227 then regulates how procurement ought to be conducted. And we submit, my lady, that these two critical aspects have been violated in the current text and the effect of the current PPP framework. Specifically, my lady, the Constitution establishes Parliament as the body that is mandated to pre-approve all public expenditure, including the raising of revenue, borrowing, approval of plans and projects, and the allocation of funds towards their expenditure. However, when you look at the current Public-Private Partnerships Act, so allow me, lady, to explain how public-private partnerships are structured. They're structured in such a way that, unlike, they're not just a procurement tool. They identify a project, they approve that project for implementation, they approve how that project is going to be funded, they approve the sources of that funding for that particular project, they approve how the project is going to be overseen and reported until conclusion. Now, when a PPP project is therefore approved, they're not just approving, it's not an executive level approval of a procurement method. It's a whole prioritization of projects and allocation of resources and identification, and including the giving up of revenue raising measures. Now, the challenge with allowing, we have three concerns, my lady. One is Parliament is completely excluded insofar as the approval of PPPs is concerned. Yet the Constitution bestows on Parliament the role to pre-approve all public expenditure. And two, my lady, our second concern is there are 4 procurement methods listed under the PPP Act. One of them, we have an issue with the privately initiated proposals. And specifically, our concern relates to the carte blanche discretion that is afforded.
You call it the
privately initiated proposals, PIP.
Yes.
So the nature, I'll be able to explain, and our concern really is that the Cabinet Secretary is given wide powers insofar as deciding as to whether that particular mode of procurement can be subjected to competitive bidding in order to comply with Article 227 of the Constitution. And third, my lady, our concern relates to Article 227 of the Constitution then regulates how procurement systems or the qualities that a procurement system ought to elicit under the Constitution, including fairness, equity, competitiveness, and cost effectiveness. The Public Procurement and Asset Disposal Act has been enacted, when you look at the long title of the Public Procurement and Asset Disposal Act, specifically to give effect to the Article 227 of the Constitution. That is the primary legislation insofar as public procurement system is concerned in Kenya. And when you look at Section 3 of the Public Procurement and Asset Disposal Act, it lays out a very long list of principles, guiding principles that are supposed to be complied with by all systems of public procurement. Now, despite the fact that that is the act, that is the primary act insofar as procurement is concerned, sections of the Public-Private Partnerships Act exclude its applicability to PPPs. And our argument then, my lady, is if the Constitution is being operationalized through the Public Procurement and Asset Disposal Act, when you exclude that act from applying to a specific set of procurement, you're essentially excluding the applicability of Article 227. And that, my lady, is our third issue. And lastly, my lady, we're arguing that the nature of PPPs, my lady, is that they're long-term, usually between 20 and 30 years. Article 201C of the Constitution requires intergenerational equity insofar as the utilization of resources and the apportionment of the burden of that utilization is concerned. And our concern, my lady, is that currently we have about 41 PPP projects that are in the PPP pipeline. There are 41 projects that have been are in various stages of procurement and approval. Out of the 41, 10 of them are already being implemented. Our concern is that when you exclude Parliament in the pre-approval of these PPP projects, yet these PPPs are going to be implemented over a period of over 30 years, you then allow for PPP projects and private rights that have been acquired under the PPP agreements to go on for a very long period of time without constitutional scrutiny. One, Parliament was not involved in approving this particular project, so we're not sure as to the public interest and value for money considerations for the projects. These projects imposed debt obligations, including contingent liabilities, which then affects Kenya's debt burden and the debt stock. Essentially, therefore, the sustainability of public expenditure comes into question because we are not very sure the extent to which these contingent liabilities are sustainable. Article 10, my lady, 2 requires sustainable development as a national value and principle of governance. Article 201 requires intergenerational equity. And my lady, with respect to the accountability and oversight of this project over this 30-year period, Parliament is excluded. It is given no role whatsoever in overseeing these multi-billion, multi-year projects. And essentially our argument then, my lady, is that to ensure that we do not burden Kenyans with intergenerational burdens to the benefit of private parties, we are requesting that a declaration of unconstitutionality then apply retrospectively and that the court retains jurisdiction through a structural interdict to guarantee that these PPP projects that are in the pipeline are reviewed in a manner that then brings them within the confines of the Constitution. And therefore, my lady, the reason why we are arguing that PPPs essentially are public spending, they'll probably tell you that a private party gives money and then oversees the implementation of a project and then recoups money from the project. That's only one way in which PPPs operate. The other way is the government agrees to pay annually a particular amount of money, what you call availability or annuities, which then utilizes public funds. And besides that, there are PPP projects which require counterpart funding upfront. That means that the private party gives a particular amount of money, the national government gives a particular amount of money. So essentially, there's the utilization of upfront public funds. Besides that, when you look at the PPP Act, there is something called the Project Facilitation Fund. Wherever a private party submits a proposal for the building of a project or infrastructure and it is successful, it's required to pay 1% of the cost of that particular project, which then goes to the Project Facilitation Fund. Now, this Project Facilitation Fund is used to pay something called viability gap funding. Viability gap means that a project might be socially desirable but economically not viable, in the sense that a social hall, for example, or hospital, those projects which do not have economic viability are not bankable. You cannot be able to recoup money. So what the government usually does, it utilizes this viability gap funding to be able to incentivize the private party to invest in these particular projects that are otherwise not economically viable. Now, besides that, each of these PPP projects, they have risks which they apportion between the parties, between the private party and the national government. Each of these risks come with contingent liabilities. So these contingent liabilities are not going to be paid from the PPP projects. They're going to be paid out of the public coffers. Say, for example, foreign exchange risk. If, say, for example, there's inflation or there's forex movements and the dollar goes way beyond what was intended under the contract, the additional money is going to come from public coffers. So essentially our argument, my lady, is that the way in which public-private partnerships are implemented in Kenya is in such a way that they involve significant expenditure of public resources. They require oversight over a very long period of time, yet despite the Constitution imposing requiring Parliament to pre-authorize all public expenditure, PPPs are excluded. The Act itself excludes Parliament from any role whatsoever, and it places this obligation on the PPP committee. And our argument, my lady, that to the extent that the PPP committee is the sole entity that then approves PPP projects to the exclusion of Parliament, then the PPP Act is unconstitutional. My lady, with respect to the issue of the applicability of the Public Procurement and Asset Disposal Act, we already explained this. However, my lady, our argument is that the only qualification that both the PPP Act and the Public Procurement and Asset Disposal Act place for excluding the applicability of the Public Procurement and Asset Disposal Act is if a project is fully funded by private party, then the Public Procurement and Asset Disposal Act that is intended to apply the provisions of Article 227 is excluded from applying. And our argument, my lady, is that PPPs, or even if a private party funds a project wholly, full funding of a project does not constitute an exception to Article 227 of the Constitution. Essentially, and even if they were to exclude the applicability of Article 227, argument also is when a private party provides money, it's equivalent to a bank extending money as a loan. This money does not come free. It's money that has to be paid by the government, either through levies or charges. And therefore, when the exclusion of the Public Procurement and Asset Disposal Act is pegged on whether a project is fully funded by a private party or not, it's based on an illusionary reading of what exactly a public-private partnership is. It's essentially a loan that is extended to the national government, except that in this particular case, the private party uses that money, then recoups the money either through direct payments from the national government or from levying tolls or any other forms of levies to recoup the money. Therefore, my lady, our argument with respect to this particular case, and specifically when you look at these provisions in the context of the implementation of the JKIA and Kentucky projects, you realize that the privately initiated proposals are proposals which a private party comes up with an idea, submits it to a government entity, the government entity looks at the idea, then decides we're going to implement it. Now, when Article 227 requires competitiveness, transparency, and accountability insofar as the systems of procurement are concerned, when you look at the PPP Act, the CS is the one that has discretion to decide if a private party approaches me for whatever reasons and then gives me a particular project. The Act requires you to submit that particular project to the market to ensure or to get additional bids from other people, so at least you're able to know whatever is quoted in this particular privately initiated proposal, is it at market value? Can we be able to get the same level of implementation, but from a different provider? But what the Act does, instead of making it mandatory for the CS to subject all privately initiated proposals to market testing to ensure value for money, it gives the CS unbridled discretion to decide whether or not to subject privately initiated proposals to competitive bidding. To use the example of JKIA, all JKIA and KETRACO deals were all initiated privately. Now, the contention was that there were three other bids which were submitted to the CS for purposes of undertaking renovations at JKIA. But the fact that only the CS has this discretion, it is not guided, there are no objective criteria, there's no duty to provide reasons, there's no process for review of that particular decision, there's no way we can be able to contest it. These other privately initiated proposals were ignored, and only one particular person was awarded that particular contract. And therefore, our argument, my lady, is that privately initiated proposals, to the extent that they give unbridled discretion to the CS, they violate Article 227 of the Constitution. Lastly, my lady, with respect to the issue of structural interdicts, the problem we have currently is that while the court may agree with us and declare the PPP Act unconstitutional to the extent that, one, it excludes Parliament, and then two, excludes the applicability of the PPADA, the problem we have is that we already have projects that are already ongoing. We don't know for sure what were the terms of the agreements of these PPP contracts. They're multi-billion, multi-year projects which impose repayment obligations over generations. Now, if we allow an unconstitutionally signed contract that excluded Parliament and excludes parliamentary oversight, the challenge is that this unconstitutionality is going to be spread and be implemented for the next 20, 30 years. We have, as I mentioned, my lady, at the beginning, 31 projects that are still at various stages. Either they're being undergoing a feasibility study or project development stage, or projects are being actually, the terms are being negotiated. We need to be able to ensure that the respondents come back to the court and report that, based on the determination of this court on the constitutionality of the Public-Private Partnerships Act, we have done this and this to ensure that all the projects that are in the PPP pipeline have complied with the court's direction. We also need the respondent to come back to the court where the court is inclined to suspend the declaration of unconstitutionality. We need Parliament to come back and report that these are the measures we have undertaken to ensure that this act is reviewed this particular period of time to ensure the regularity and constitutionality of the PPP projects that are being undertaken. My lady, without a structural interdict where the court retains jurisdiction, we see a situation based on the experience of JKIA and KETRACO, where the executive was very invested in those particular projects. We see situations where the orders of this court might not be taken seriously, and the entire regime of PPPs continues to operate outside the Constitution and to the exclusion of democratic accountability through the involvement of Parliament. Therefore, my lady, we submit that the current circumstances, and specifically the nature of PPPs, warrant this court's intervention. One, in ordering the retroactive applicability of the declaration of unconstitutionality, we provided circumstances and justifications and case law, and importantly, retaining jurisdiction to ensure that these orders, the orders of this court, are complied with.